Yeah, we let the dog out after I leave.
Okay.
Video issues. I just minutes and you can see me. Okay, apologies. So can everyone hear me?
Oh, no, it's her batteries. His voice system is like this.
Okay, welcome everyone to yet another meeting of the Public Meetings Law Rules Advisory Committee. We're going to start today. I just want to make a few comments and then we are going to do a roll call. And so our new compliance and enforcement coordinator will do a roll call of everyone's names. I'd appreciate it if you'd identify yourself as being here or not. My brief comments to begin with is I wanted to follow up on our last meeting and the one before it, but the last meeting with Scott, for example, had raised questions about did the last meeting cure any public meeting law violations we had at the prior meeting, when the system wasn't working, etc. I wanted to both reassure the members of the rulemaking committee of the RAC that you're not going to be held responsible for a violation, and use it to kind of discuss why that is. And why that is that the RAC is not a governing body for the rules that we're discussing per the public meetings law, because when you submit your comments and suggestions and recommendations and objections and everything else, you are submitting them to an individual public official, not to another governing body or public body. And I can, take your recommendations, and plenty of them. I appreciate your recommendations. Most of you are the people out in the field who are trying to make these laws work for your governing bodies. But I can also change your recommendations before we publish a final notice of adopting the rules and present them to the commission. So I just didn't want anyone to think that you were a governing body that was going to be held responsible if there was a public meetings law violation here. So any thoughts or comments there? So before we jump into the next tranche or set of rules that were sent to you, I will have Casey do a roll call.
Okay, you can just indicate that you're here, like Stephen said, we would appreciate it. Adam Adpana. Beth Woodard.
Here.
Brenda Sanchez. Recommended.
I'm here.
I can't hear Brenda.
Yeah, well, hold on a second.
Hello, I'm here. Brenda Sanchez here.
Our audio is super broken up on our end. Maybe try someone else's. Wait, let me try. Oh, that's not what I wanted. Your laptop's having issues. And then turning your volume up.
Yep. Apologies.
Bingo.
Okay. Carolyn Shields. Courtney Sneed.
Carolyn Shields, I'm sorry, I'm here.
Chris O'Grady.
Present.
Raghav Shan.
I'm here. Thank you.
Gabe Shepard. Hasina Wittenberg.
Present.
Jeb Bladine.
I'm here.
Joe Barker. Corey Tate.
Yes, I'm here.
Chris Wright. Liz Bouther Branch.
She's joining them.
Mallory Roberts. Matthew Call.
Here.
Michelle Smith. Nancy Sandoval.
Here.
Rob Bovitt.
I'm present.
Sarah Zavala.
Present.
Scott Winkles.
Here.
Sherry Kinsey.
Here.
Therese Holmstrom,
Here.
Tiffany Johnson.
Present.
Thank you.
This is Liz Father Branch, and I'm here as well if my name has already been called.
Thank you. Okay, so we're going to jump into starting with Rule 199-050-0040. Notice requirements. So I will read and discuss. So subsection 1, public notice is required for all meetings of a governing body. The purpose of providing public notice is to give notice of the meeting details and subjects to members of the public at large, as well as to interested persons and media representatives who have requested notice. Oh, sorry. Subsection 2, methods of notice. A, notice to the public. A governing body satisfies the public notice requirement in subsection 1 by providing notice of its meetings to be displayed conspicuously on the public body's or governing body's website. If the governing body does not utilize a website, the governing body must satisfy the public notice requirements through other means, such as community postings, bulletin boards, newspaper notice, or any other means that provide I have to fix that sentence for construction. Any other means that provide actual notice to the general public. Subsection B, notice to interested persons. A governing body satisfies the interested persons notice requirement in subsection 1 by providing notice through I, interested person lists, mailing lists, or other lists of persons or groups maintained by the governing body to provide notice or communications. Double I, social media platforms normally utilized by the governing body for communications. Triple I, any other means to provide actual notice to interested persons known to the governing body. Subsection C, media notice. A governing body satisfies the media notice requirement in subsection 1 by providing notice to those media representatives who have requested notice. Subsection I, in the method requested by the media representative to receive notice, or subsection 2I, by any other means determined by the governing body to provide actual notice to media representatives known to the governing body. So I'm going to pause there and see if there are any comments about the method of notice.
So the way that this reads to me, I'm bilingual. So if it doesn't make sense to me in Spanish, it's not going to make sense to me in English. If you don't put the ors after each of the subsections, that means I have to check off all 1 through 3 or 1 through 2 under like notice for interested persons. In my head, that means I have to do 2I and 3I. So do the ors need to be after that for clarification? Like you did in method 2?
Yeah. Yes, I mean, I don't think that it certainly isn't my intent that in sub B that it has to be all 3 of those.
Okay, so can we add the ors at the end, please?
Yeah. Anyone else?
I have a couple of comments.
Okay, go for it, Rob.
I think adding the or might satisfy my first comment about if it's I, or I, that might satisfy, because I know some folks use this, some folks don't, but my bigger comment is about tying interested persons, which really aren't defined here, back into A. And so I'm not sure exactly how this works, how long it lasts. I know that at least the clients that I've had have typically had an interested person's email list. Media is included, other people are included. And that's, I think, fairly common, but I'm not exactly certain. With regard to C, it does have an or, which I think is critical, but I can still see a potential issue here about maybe forcing local governments to do things they don't currently do and increasing workloads. You might have someone that says, no, I don't really want to get these notices by email. I want to get a phone call. And the way I read it, if they don't provide their email address, it wouldn't qualify under little 2, and you'd be forced to set up a whole new system to make a phone call to somebody, which raises my, I guess, greater concern again, and I'll sound like a broken record again. I'm not sure what we're doing here, because I think we're redefining things that have already been defined pretty well under Oregon law.
Okay. I will think about that. So, Scott.
I got some feedback on this from one of our city attorneys, and what she flagged was in this section, the method requested by the media representative. We already have a method for sending out these notices. I mean, I'm not sure, it doesn't seem valid to me to have a city councilor on the hook because somebody got an email instead of a text or a phone call. So there's a method to subscribe to notices. We've kind of got this down. You're overturning some longstanding practices, and I'm not sure you really have the legislative authority to do that.
Okay. Liz.
Hi, this is just coming up from all the meetings for me. When I sat through the first meeting, it was, I think where, I don't even know where to begin. I think what sometimes the problem for me with these is the different levels of commissions, boards, subcommittees, and so on and so forth. Is this requirements across the board, or that everyone should be doing, or
Yes,
that's sort of what makes it confusing for me. And I think some of it comes up as a training issue as opposed to maybe setting the rules this way. You know what I mean?
right, but the requirements to give notice of a public meeting, if your committee, subcommittee, whatever it is a governing body subject to public meetings law, the requirements to provide notice are there regardless. This is going to apply to everyone who is subject to the public meetings law.
Okay, I'm not saying that. That part I understand. But I'm saying when you're talking about media lists, when you're talking about adding other people to the meetings, sometimes it comes off to me that it should be part of the training of, your commissions or your groups, as opposed to written this way, because just like the Ms. Sandoval, who talked about other language learners, it starts to get real legislative, legalese, whatever you want to call it, without being clear about what it is that those groups are supposed to do. And when you have people on the commission that are just coming from the community, this may not be clear to them.
Right.
So I'm asking that question. What portion, is there any portions of like the I's, the double I's that could probably be within the, saying that the notice needs to be there, but a piece of this could probably be within the training of how you train your commissions and your boards?
Well, I agree all of it. I mean, I think it could be in the training. I need to think a little bit. I see Scott's point and Rob's as well about the, especially in the media one, in sub C, in the method requested versus in the method that the governing body has adopted for providing notice. As long as that method provides actual notice. So I absolutely will look at that again. In terms of your comments, Liz, I think, yes, some of it can be provided in the training, but not everyone is going to get the training. I mean, there are a lot of governing body members out there who will never, for whatever reason, won't get the training. And so if we're not putting those basic requirements into these rules, the rules are where they're going to look for the requirements.
Got it. That made it a little clearer, but hopefully there's at least one staff person then that would understand the rules and could put it into plain language for the rest of the group.
I mean, I do recognize everyone that, and this may be something for future. I mean, Rob and I talked about it at a conference, this was a while back, but a future legislative fix, like everyone here who's actually on a governing body or a governing board, realistically, do governing body members really know how the notices are sent out? No. I mean, my 9 commissioners, they are held responsible for the notices that we send out, but the practical effect is no. The problem, of course, is that the law is written such that the only people responsible for the government, for making sure the public meetings law is followed, are those governing body members. I think in the future, could I see something like a law commission or an equivalent really sitting down and thinking about, should the public meetings law be written so that the technical ministerial things that staff members do are separate from the violations portion? Perhaps. I mean, I don't think that's something we can accomplish in these rules. But for another day. Sherry. Kinsey. Here we are.
Lakeside is a good example because I was new, brand new, and we had a new city manager that had transferred from somewhere else. And we had 4 or 3 brand new city councilors at the same time. So it was a whole new council pretty much. And the others that were remaining were not really active in it to where they were able to provide training or anything like that. So what our training was basically just reading through what we could read through online.
So
There are still some hands up.
yeah. All right, Matthew.
Thank you. Just, I guess, 2 small comments. Under 2A, the last line where it says providing actual notice to the general public, just whether that should be removed word actual from there. So it's just provides notice to the general public. And then under 2C, little 2 I's, instead of the governing body, replacing it with a governing body. there's references to a governing body and the other provisions. And it seems to be inconsistent. And I guess the question of when you start looking down at the levels with the commissions and committees, whether they actually have the lists or whether it's the governing body that they're reporting to or recommending to have those lists to be doing it.
Yeah, I mean, like I said, I think that's sort of, we rely on staff, but the problem is the staff with those lists, you know, how much can a governing body rely on them is the problem. Scott, we'll get to you, Joe, sorry. Scott.
I just wanted to add, because this conversation made me think on this concept I brought up last time about an intentional and knowing violation. And so because all of these notices, that's a function of your professional staff, your manager, your recorder, your city attorney are all involved in that. So I would think that in order for someone to be sanctioned for a violation, they would actually have to be intentionally and knowingly have participated in a meeting that wasn't properly noticed. And I think you could probably do that within your prosecutorial discretion.
Taking notes. That under consideration, Joe. You're muted, Joe. Okay, any other questions on subsection 2? Comments, I mean? Okay, I will move on to subsection 3, content of notice. The public notice must identify A, the time, date, location of the meeting, and if reasonably possible, the electronic link or telephone access information to allow members of the public to attend the meeting by telephone or electronic means. B, the agenda or list of the principal subjects anticipated to be considered at the meeting. The agenda or list of principal subjects must be specific enough to permit members of the public to recognize the matters in which they are interested. Posting the agenda or list of principal subjects does not prohibit the governing body from amending the agenda at the meeting to include other items. C, the name and telephone number of a person of the public body to contact to request an interpreter or other communication aids. As an alternative, the notice may indicate that the governing body will provide a sign language interpreter or other communication aids at the meeting. And D, if a meeting will consist only of an executive session, the notice must identify the specific statutory provision and state the purpose for holding the executive session.
Real quick for Joe, to unmute yourself, you might need to press *6 if you're having trouble unmuting yourself with your phone. Again, it's *6.
So, any questions or comments on subsection 3, content of notice? Sarah?
I just wanted to ask if 3A requires that an electronic link be provided, even if the meeting is only being held in person for the specific attendees.
The reason for that is, sorry, I don't have my statutes up. Hold on a second, like pull up the right statute. I think it's 670. Oh, I see.
The group can't see it though. The group see.
Hold on, let me find the right. All meetings, 670 sub 3, all meetings held by a governing body excluding executive sessions must provide to members of the general public, to the extent reasonably possible, an opportunity to attend in person or by video, electronic means, etc. So the reason for this language in sub A is the addition of that to 192,670. Scott.
I believe Matt had his hand up first.
Okay, Matt.
Thanks, Scott. Also on 3A, would it be permissible, or, you know, having the time, date, and location of the meeting, but then having a governing body provide a contact number or request people to obtain the Zoom meeting information because it may not be available at that time, or, you know, in the past, there's been issues with folks attending virtual meetings, causing to disruptions of the sort. And so there was a period of time where you had to request the information to be provided.
I will run it up by DOJ. I suspect the answer might be no, but trust me, I think state agencies certainly, but the whole Zoom bombing or whatever phrase is appropriate is a problem that everyone's aware of. And so I don't know that simply saying you can call us and ask satisfies the statutory requirement to make meetings available. It could. I mean, I'll double check that.
So I would encourage you to keep reading down in that statute, because there is an opt-out for undue hardship. I believe it's phrased as an undue hardship. So a public body is not required to do, if it's an in-person meeting, they're not required to do the hybrid option if it creates if it's beyond some sort of reasonable difficulty standard. And so if you have a city council that's been Zoom bombed, or the harassment, or they, you know, not all of my members have access to broadband. So not everybody is actually required to do that. And there are reasons the city council would not do that, that are legitimate under the statute. So
maybe
you do need to keep in mind that when drafting. I'll submit further more clarified comments.
Maybe we just need to beef up the language of the if reasonably possible.
Yeah, I forget how I actually negotiated this bill, so I'm trying to remember how it ended up, but it's not an absolute requirement, which will become relevant in later parts of our story today.
Yeah. I mean, that's why I put in the if reasonably possible, but I understand that if we need to look at whether that needs to be a broader statement or not, we will. Any other questions or comments on the content of notice section?
Quickly piggyback on Scott's comments. I was negotiating that language as well, and I think the special districts want you to keep in mind that they have literally hundreds of tiny little members with very limited resources that often conduct their public meetings, you know, at Joe's house on Wednesday nights, and they do so, and they don't have any technology or anything like that to conduct their special road district meeting. So just keep them in mind, I'd suggest. And then my only other comment is on paragraph D. I don't think you're trying to imply that if a meeting consists of more than an executive session plus an executive session, that you don't also have to notice the specific provisions in ORS related to the executive session, but that's kind of how that paragraph D reads. And then I'll stop saying this after this time. My ongoing concern about trying to restate existing law, I just think is fraught with risk.
We'll move on to subsection 4. Timing of notice. The public notice must be issued in advance of the meeting in accordance with the following timelines. A, regular meeting. As much advance notice as reasonably possible, but no less than 48 hours advance notice. Providing notice of less than 48 hours is allowed if the meeting is held as a special meeting. B, special meeting, at least 24 hours advance notice. C, emergency meeting. As much advance notice as reasonably possible given the emergency circumstances. An actual emergency must exist. Sub I, the governing body must make a finding as to the reason why the meeting could not be delayed to allow at least 24 hours notice, and the meeting minutes must describe the actual emergency justifying less than 24 hours notice. Sub 2I, the governing body must attempt to contact the media or other interested persons to inform them of the emergency meeting by telephone, email, social media, or other method designed to provide actual notice. Sub 3I, if reasonably possible under the emergency circumstances, the emergency meeting notice must be conspicuously displayed on the governing body's or public body's website. Yeah. You're muted. Sorry.
All right. I'm sorry, I hit the wrong button.
That's okay.
My interest here is that the ORS includes a phrase that's important to media. It's calling for notice to be reasonably calculated to give actual notice to interested persons, including news which have requested notice. I hope that there might be some reference to that. The reason it's important is that in many cases, it is the media that is the primary provider of notice to interested people. And there are times when governing bodies might or might not provide notice to the media in a way that allowed for that widest notice. For example, in the case of a community newspaper, notice reaching the newspaper in time for its print publication. So that's, I don't have a specific request for that, but just hoping that that the rules might recognize that reasonably calculated language.
Well, Jeb, I guess my question to you is, and that may be a rephrasing we have to do in subsection 2 on methods of notice to the media. In subsection 4, do we need to sort of repeat that in terms of the timing of an emergency meeting notice?
Understood. There are just, over the years, I've seen times where a governmental body was able to give notice prior to a newspaper publication, but simply didn't get it done. And so it's oftentimes we've actually used that specific language in talking with governing bodies about reasonably calculated to give actual notice. Seems like it might refer to providing timely notice to allow publication in a newspaper. That doesn't override any of the protections against special meetings on short notice and so forth that all exist within the law. So again, it's been a part of the ORS forever, and it's been useful for local media, I think. So if there's some way to reference that, it would be something we'd support. Thank you.
Let's see now.
Yeah, Susan, can I ask, why the reference? What was your thought process in little 3I there about post, if possible, reasonably possible, posting it on a public body's website, to sort of piggyback on Rob, who took up my little torch there. Thanks, Rob, about special districts. They don't have email and they don't have websites. So I'm concerned that we are calling out potentially. I mean, I know City of Beaverton has a website and TVFNR has a website, but saying reasonably possible, like why highlight a website when I would say 70% of districts or, local governments, if you take them all in totality, don't have websites.
So this was more to link it to the prior section on the methods of notice. But I fully, that we see those cases of a little road district with like 33 members, and I fully understand that they don't and shouldn't be expected to have a website. And yes, they're meeting in so-and-so's living room. So again, I added it with the idea of if you're giving if it's an emergency meeting, you need to give sufficient notice, not just on time, but to the people that you would otherwise notice a public meeting to, as much as you can under the circumstances. So if you have a website and you can post notice there, you should do that even if it's an emergency meeting. But obviously there are plenty of districts where they won't have that as an option because they don't maintain websites. So it's not that it's a requirement to do so or create a new requirement that all of them have to have websites, but more of a, if you're going to have an emergency meeting, you need to make as much effort as possible to notify as many people as possible.
Yeah, I hear you on that. I think that it'd be difficult for even a very sophisticated local government to immediately go post an emergency. I mean, I think it would just be difficult. There's code, you gotta write, you have to log into a website and actually do things. And if it's an emergency, it's probably unlikely that somebody's going to be able to go in time to be able to do that.
Sarah.
Hi, I just have a question about the Oregon Transparency site and how that plays in. We use that as a state agency posting for public meetings, and I didn't see that under methods of notice, and I do believe it's required for state agencies to post there. And I realize that doesn't cover all scenarios necessarily, but that is the one-stop shop for public meetings that some of us need to post to.
Yeah, and I probably should add that to some too. Okay, Matthew.
To go back also to the 4C3 part, conspicuously displayed on the website. Not sure if you mean it, where they would typically post a meeting if they have a calendar, or whether it has to be on the homepage. It seems like that would be pretty a wide area that it could be displayed.
Okay. I'll try to clarify that point. Any other comments or questions on this section? We're gonna take, before we move on to public attendance, let's take a 10-minute break. We'll come back at like 5, a little after 5:02. Thank you, everyone. Okay.
Okay.
Okay, excellent. It looks like most of us are back. All right, we're going to move on to the section 199-050-0050 on public attendance. And I may add a subheading to that, public attendance, semicolon, public comment. So subsection 1. All meetings of a governing body other than executive sessions shall be open to the public. Subsection A, meetings may be held at locations as specified in ORS 192.660 sub 4. B, meetings must be held at accessible locations as specified in ORS 192.660 subsection 5. And C, meetings may not be held at discriminatory locations as provided in ORS 192.660 sub 3. Subsection 2, to the extent reasonably possible, the governing body must. Yeah, Adam, you had a question?
Hi, yeah. I don't know if this is the right time to point it out. Sorry, I'm a little new here. I missed the last couple meetings, but is 192630 for those 3 references?
Oh, you're right. Sorry. I have, thank you.
No problem.
I have, since we've had executive session for a long time, my automatic is to reference 660, but that is correct. Okay, subsection 2. To the extent reasonably possible, the governing body must, A, provide members of the general public an opportunity to access and attend meetings by telephone, video, or other electronic or virtual means. B, for meetings held by telephone or other electronic means of communication, make available a place or an electronic means by which the public can listen to the meetings in real time. The place provided may be a place where no member of the governing body of the public body is present. C, for an executive session, provide representatives of the news media an opportunity to attend the executive session in the same manner, such as by telephone, video, or other electronic means, as any other person, including but not limited to members of the governing body who is in attendance at that executive session. So let's take a break there. And I see, Scott, you have your hand up.
So could you scroll back up? I was looking at that executive session attendance piece.
Can you scroll down a little bit?
Can you?
A little more. There.
So so for a member of the media to attend an executive session, and the executive session is held in person by the public body, the governing body, are we saying that the media could attend electronically?
What the commission has said previously and what this rule embodies is that you cannot require the media to attend in any manner different from anyone else. So if the meeting is in person and there is no one attending the executive session by telephone or video, like you're not holding an executive session with people, another company or something calling in, then you could say that the media can attend, but they must show up in person. But what you can't do is hold an executive session where people are attending by phone or video and have a requirement that the media show up in person.
So if one member of the public body is participating electronically, then we would have to let media attend the session virtually by this rule. And I guess that's what you've been said all along.
Yes.
That's interesting. I don't think you could do that.
Well, okay, so then
I think you need a bill. I think a local government, particularly one of my members who are constitutionally home rule, could define attendance, as there's no clear and unambiguous preemption in the statute. I think you're going to run in. I think that's a problem.
I'd like to add to that too.
Please, I yield to my dear friend Rob.
So a piece of legislation was actually offered to do what's described here, and the legislature rejected it in light of objections, some of which Scott has raised, others of which were raised by some of his members related to the security of executive sessions. So I agree with Scott. I don't think you can do this. I think you need legislation. I also have a second layer of concern about this paragraph because I think it functionally eviscerates at least two exceptions to the media's right to attend executive sessions that are baked into state law. There's at least two types of executive sessions, in other words, that media cannot attend or that can be excluded, and this seems to eviscerate that. So I have two objections to this paragraph, the way it's written.
And certainly not my intent, but I see the point. If you get the chance, will you send me the bill number where they considered it?
You bet. Happy to do that. And happy to also send you the statutory citations to the types of executive sessions where the media can be excluded.
I have those. It's 3 and 2D.
And if I could reclaim my time, I need you to understand exactly what this means, because right now we have a scenario where non-professional media are allowed to attend these executive sessions. They've leaked the contents of those sessions. We have no way of knowing who's on the other end of that phone call or that Zoom to confirm that it's only it is only a media representative. The legislature just passed a bill that gave us the ability to talk about certain security, cybersecurity, physical safety issues in executive session. And so now we would be required to let someone call in via Zoom and listen into that, not know who they are. They may not even be allowed we can't even confirm that they're allowed to be there by the statute. And we're going to talk about our cybersecurity and the physical safety concerns. And I've got city councilors who are getting death threats. Yeah. So there's no scenario in which we could ever support or accept this rule, these ordinances drafted, and I would seek a legislative fix to cure this.
Okay, Therese.
I just want to say that I agree with Robin Scott's concerns raised about, I think that this, as drafted, this rule exceeds the scope of what the media is currently allowed to do in terms of attending executive session. And for the same reasons Scott just mentioned, I've had members who want to designate a public place for media to attend rather than electronic.
What do you mean by designate a public place?
Like in the public notice, right? The public notice would would designate a physical space. From,
right, where
Yeah.
they tend to observe virtually, basically.
exactly.
Okay. Deb,
As usual, I agree with Scott and Rob. Guys, this is a really touchy area. This is an area that has different feelings within the news media, actually. There are interests of people who cover bodies a long ways away and are unable to attend executive sessions without huge cost. And then there's both sides of that within the news media world. Some people think that it should be restricted. I'd just like to raise the point that it might be worth considering whether or not even the members themselves ought to be able to attend by Zoom. I mean, just as a news media person attending by Zoom could have anybody in the room watching, which wouldn't be possible in person, so could a member of a public body, and it wouldn't be the first time that something like that could possibly happen. So the whole issue of attending executive sessions by Zoom is problematic, and there's mixed feelings within the media about it.
yes, and I have heard from plenty of media people wanting us to address it, and I do hear you, Scott and Rob. I'll go back to DOJ with this one. Joe.
I would like to add a subpart E to that if the meeting is only executive session, it should be a constructive notice of time, place, and manner, and that the meeting will be called into open session and then convene into executive session. And I do agree with Scott, Jeb, and Rob that executive session should not be held by Zoom. I mean, there are a lot of reasons besides cybersecurity, such as if you're talking about your water plant and the types of security that you have to have around your water plant or your wastewater treatment plant, or if there are any type of investigations going on, those all need to be held behind closed doors and should not be subject to Zoom meetings. You should be in person.
Okay.
And if I may add one other point, considering I was having technical difficulties, the content of notice, this actually goes back to 0040. Public notice is actually constructive, which basically deals with time, place, and manner. That's pretty clear under Mullane versus Central Hanover Trust. You got to provide constructive notice. The meeting, if you're going to do a Zoom meeting, then it should also include the link to where you can access it. I'm just all over the board today, so I'll just shut up right now.
Okay.
I've had technical difficulties all week, and
I just want to address your request for a subsection E, that if the meeting is a standalone exec session, that you have to have a open in public session first. I do not think that is a requirement of the law. You can have a standalone executive session without ever starting the meeting in a public session, but you would have to provide sufficient notice of the standalone executive session, meeting both the notice requirements of time, etc., And then that notice would have to include the statutory provision and a statement of what the point of the executive, what the purpose was.
I will.
That is different from if you're in a public session and you're moving into an executive session. If that's the case, you only have to give notice of your public session, and in your public session, you can make your statement of why you're going into exec.
I will respectfully disagree on that, based upon various states' public meeting laws. If you are only holding an executive session, you first have to convene an open public meeting to announce you're going into executive session, then go into executive session. Otherwise, we have a very similar scenario in which I was involved in. And it was constituted as an illegal meeting because of improper notice.
All right. Any other comments before we move on to subsection 3? Public testimony. Okay. There we go. So subsection 3, when public testimony is permitted, the governing body must A, allow oral testimony by telephone, video, or other electronic or virtual means if in-person oral testimony is allowed, and B, allow written testimony, including that submitted by electronic mail or other electronic means, if in-person written testimony is permitted. The governing body may require the written testimony be submitted sufficiently in advance of the meeting so that the governing body is able to consider the submitted testimony in a timely manner. Subsection 4, the Public Meetings Law, ORS 192.610 to 192.705, does not provide the public the right to participate or to provide public testimony or public comment. In the absence of a statutory or other legal requirement to hear public testimony or comment on certain matters, a governing body may conduct a meeting without any public participation. And subsection 5, unless otherwise provided by statute, charter, or other organic law of a governing body or public body, the presiding officer has inherent authority to keep order and to impose any reasonable restrictions necessary for the efficient and orderly conduct of a meeting. If public participation is to be part of the meeting, the presiding officer may regulate the order and length of appearances and limit appearances to presentations of relevant points. Joe.
This is going to sound like I'm stupid and don't understand things, but I equate when a city or local government creates ordinances, resolutions, policies, and practices, that would be, in my mind, to fall underneath the Administrative Procedures Act, which is no different than the EPA or the Housing Department, where they have rulemaking authority. So my problem with 4 is the passiveness of the public may be allowed to comment. I think it should be a mandatory requirement that public should be allowed to make public comment because it opens up dialogue. It creates for better attentiveness and transparency. And why should part of the state government be required to accept public comment and the other part of the state entities don't?
So
I think the APA Act applies here to local governments as well.
That, I mean, a valid point that everyone should be treated the same, but what I'm saying here, especially in 4, is there is no requirement in the public meetings law, and we only have the jurisdiction to enforce the public meetings law. It doesn't exist in the public meetings law. There is no requirement for public comment.
Scott, I would help. I would appreciate help on that one.
Susan's right.
Chris. Oh, Rudy, sorry.
Yes, I just have a comment on section 5. Only because the way that the statute is currently interpreted also allows for removal, but we don't explicitly say there's removal. It just says to impose any reasonable restrictions necessary. And to me, in that reading, actually takes the ability for removal in certain actions if there's threats or consistent, ongoing, like very disruptive language not addressed there. So I would like removal to be addressed as well. And also the notation that if they're removed from one meeting, that does not restrict public for future attendance at public meetings. And then the last portion of section 5, it only mentions public participation, but not also public comment. I think in terms of how public meetings are conducted, there is a difference between a public participation and the public comment period, because we can also regulate the order and length of public comment. And I would like both of them to be mentioned in addition. And those are my comments on this section.
Okay. And I'll think about the removal. I mean, in talking about it with DOJ, I think I will go back to them and see why. Because basically I'm looking at the AG manual, which has that sort of language about the inherent authority, which is what we at most state agencies rely on anyway. But
yeah, I guess the way I read this, it would remove it. It limits it to reasonable restrictions, and removal doesn't, in my reading of what a reasonable restriction is, it isn't the same as a removal. But maybe DOJ has a different viewpoint on that.
And I wouldn't want to have this language be such that it would prevent removal. So I understand.
That's what my concern is.
Any other comments on subsection 050? Okay, we'll move on to 199-050-0055, public vote requirements. And sorry, everyone, my voice will get worse as it goes on.
Hold on a second.
No, cough drop. It's just, for the rest of you, everyone in the room knows, for the rest of you, I actually only have one vocal cord that functions, so there's the voice can be weak. Okay. 199-050-0055, public vote requirements. All official actions by governing bodies must be taken by subsection 1. All official actions by governing bodies must be taken by public vote. Subsection 2. Secret ballots are prohibited. I don't know, are they?
I'm sorry. Oh, I know. Sorry. I apologize to everyone.
Subsection 3. Results of all votes must be recorded, including the individual vote of each governing body member. For governing bodies with more than 25 members, the individual votes do not need to be recorded unless a member makes a request. Subsection 4, if written ballots are used, the written ballot must identify the individual member voting and the vote itself must be announced. Deb.
There seems to be maybe a confusion created by saying that the results of all votes must be recorded, because the law calls for either minutes or a recording. This almost suggests that those results must be a recording as opposed to minutes. But there's actually more comment on this in the next section, but I don't know whether it might say the results of all votes must be made public, not distinguishing between whether they are written minutes or a recording, but just a possible confusion with that word in that place. More on that in the next session, though. Next section.
Anyone else have comments on 055?
Carolyn Shields has her hand up.
Okay, Carolyn.
Hi, I just wanted to know if a consensus of the council would be considered a vote, or is this limiting the council to a public vote without doing a consensus?
A consensus is not a vote. I mean, you can reach consensus on this is what we're going to do, but it's not a decision or a vote until you actually vote.
Okay, I'll talk to my mayor about that.
Scott?
So I'm having an issue with the sanctions on the potential sanctions on the requirement, or it was a soft requirement that that people be allowed to participate by electronically in meetings. And if you go back and when you look at the legislation was passed in 21, and Senator Meek, who had championed this, was pretty clear in his legislative intent that this be a soft mandate and it not have sanctions attached to it. I mean, I understand the legislature did Act 2805, but there was never any, there was by his intention, there was never any plan that there be, that the idea that it be reasonable access be part of the bill, or that the city councilor or councilors or a public body be subject to fine. And I think I'm reading this as, well, one, you have councilors, and again, this is the issue where the councilors are on the hook for staff for a violation that would have been committed by staff, most likely. And there's this legislative intent question, which I know Oregon's a constructionalist state and all that, and every time a legislator says intent, a law clerk dies. But it does stick with me that we've now gone past what the legislature had intended when this was created. And maybe I need a bill in 25, and I'm certainly not opposed to doing that, but it's bothersome to me that we're now going back on agreements and what the legislature had planned for that law.
If you do have, and Scott, we can talk offline, but if there is interest in creating some sort of bill for the 25 session to address public meetings law, I'd be more than interested and can get my DOJ counsel involved to sort of sit down and work out, because the idea of the governing body members being responsible for things they don't have a clue about because it's staff or it's administrators. I think it's something that could be addressed through a legislative fix.
But these rules really do, I mean, they create that problem of officials on the hook for actions that they're not responsible for undertaking.
But I'm not so sure that they do. I mean, under the law, it's the governing bodies who are responsible for the public meetings law.
They are, but it's, again, without that intentional and knowing standard written into the statute, you have people who are going to be making good faith, who could be making good faith, or just attending a meeting in good faith and find themselves on the business end of a complaint over something that is the purview of a city manager, recorder, and attorney.
Yeah. I don't disagree. But I think that's already the state of the law. The rules are maybe bringing it into focus, but all right. Brings us to 060. We'll move on to 1990-050-0060, minutes or recordings required. Subsection 1, for all of its meetings, including executive sessions, a governing body must provide for either written minutes or audio, video, or other digital recordings. 2, the minutes or recordings do not need to be a verbatim transcript or contain a full recording of the meeting, except as otherwise provided by law. They must give, quote, a true reflection of the matters discussed at the meeting and the views of the participants, and must include the following. A, the members present. B, all motions, proposals, resolutions, orders, ordinances, and measures proposed and their disposition. C, results of all votes and the vote of each member by name, unless the governing body consists of more than 25 members and no member makes a request for a record of individual votes. D, the substance of any discussion on any matters. And E, a reference to any document discussed at the meeting, unless a reference to the document is exempt under public records law. And 3, within a reasonable time after the meeting, the record minutes or recordings of all meetings other than executive sessions shall be made available to the public in accordance with the requirement of the public records law and the policies or procedures adopted by the public body.
Adam's hand was raised first.
Okay, Adam.
Hi, thank you. So I guess I have a couple of comments on this one. First, I think I understand, it at least implies that you can, if you have full recordings, you do not need to have actual written minutes. Is that correct understanding?
Yes.
Okay, perfect. I think, I mean, maybe that could just be made a little clearer, a little more explicit here, because that's, I mean, to me, it's at least implied in the statute itself, but just because I know some boards, it's easier to publish just the actual recordings verbatim rather than have to prepare and summarize minutes. In either event, I guess my question is for subsection 3, is the reasonable time, it says reasonable time after the meeting. Does that, it doesn't really reference any like allowance for the board itself to, or the governing body itself to review and adopt or approve the minutes or recording of its meetings. I think it's a little different when it's a recording as opposed to minutes, written minutes, but either way, like, is the intention here that those need to be posted prior to confirmation adoption by the board, or should that, you know, or can that wait in the body's, you know, discretion? And if so, I think the reasonable time piece needs to be addressed there.
Okay, I think that's taken from the statute, and a couple things I will say here is your phrasing there that it has to be posted. Now, not including the next section about the new law about state agencies. I have answered twice this week that precise question, where members of the public are complaining because the governing body hasn't posted the minutes to their website. And my answer back to them is that is not a requirement of the law.
They just have to be made available.
The law simply requires that they make them available within a reasonable time. So perhaps I should clarify that point here as well, that there is a requirement to post it, but obviously it certainly doesn't hurt to post it to your website.
And that might meet the requirement of making it available to the public. But yeah, I hear that, and that's an important distinction to make there. So
it is problematic to have a rule. I don't particularly want to have a rule that says you only have to make them available, you know, because some bodies may not meet to approve their minutes for another 6 months. And frankly, I'm more than happy for this to be the district attorneys and DOJ's, you know, deal with it on a public records level. But you know, my camera's off. Oh, I'm sorry. I must have hit that by mistake. So, all right. Keep thinking about that. Jed.
I think this is the most problematic part of our entire law in my mind, but there's nothing you can really do about it with these rules because you're bound by statute. But just a couple of comments. People would be really amazed how many people, including media people, had no idea until the last few years that minutes were not required of meetings because everybody kept minutes until recent years. COVID hit and everybody started effectively recording minutes, which recording meetings that could replace minutes. And it has led to all kinds of issues in our jurisdictions. I don't know about statewide, but we had jurisdictions simply stop taking minutes that they'd been taking, say they were going to continue, but they didn't have to because they had a recording. Recordings depend so much upon the quality of the audio video equipment and the people leading it that a huge number of recordings simply don't fulfill the requirements of the law. And yet there may be no minutes. There are the questions raised if a recording doesn't clearly show somebody or tell somebody what the results of votes were, does that recording fail? And then minutes are required. There are just so many questions. And just historically, the change is huge because as jurisdictions do recordings of their meetings, it now requires listening to 2, 3, 4 hour longer meetings, trying to find where something was discussed, trying to locate the public information that well-done minutes have provided for 100 years, forever in my lifetime. The ability to depend upon minutes has gone by the wayside. I just think this is an area of law. Again, you can't fix it with these rules, but I hope that going forward, the Ethics Commission would take a real strong look at this area of the law.
Yeah, the law is what it is right now. I do think that, I mean, there is clearly, based on 192, the next section, 725, 765, about state boards being required to record and post their meetings. Obviously, I think there is that move toward us, Deb, doing all that. But as someone who has to go back when we have cases and listen to or view the meetings as opposed to the minutes, I agree. It's sometimes really difficult because the quality of the recordings, you can't always tell who is saying what. I mean, it is not the same as being able to look at minutes. So I definitely see your point, but I think that is a legislative fix.
Yeah, absolutely. Just for example, if people want to record the meetings and that's their minutes, then perhaps legislation should say that all motions, proposals, resolutions, orders, ordinance, and measures proposed must be identified as to where in the recording they appear. Again, it's become really problematic for the public and for understaffed news to try to follow up and cover what happened at meetings.
Adam?
I'm back. So two more comments. One, I guess, more general, and perhaps, I apologize that I missed the last couple of RAC meetings. I've participated in these in the past with other agencies, but sorry I wasn't able to make it for those. I guess in general, and maybe this was addressed already, to me, this rule basically regurgitates a bunch of stuff that's already in the statute itself. And so I guess from a philosophical perspective, like, should we have a rule that is exactly what's in the statute? I mean, isn't that the purpose? The purpose, my understanding of rules is to clarify the statute. To me, this doesn't really clarify that at all, at least in this particular one.
A valid point and one raised by Rob.
Okay. Yeah.
I go back and forth, obviously, and I will consider it. Part of it is that you get a lot of people out there, especially ones who don't have easy access to a legal counsel or guidance, who they're not going to go to the statute and really read it and understand it. And that's not an excuse, but if we have the rules, to the extent can the rules set forth those minimum requirements? And so I see the point about the rules should not simply be restating the statutes, and I don't disagree. But I also hesitate to sort of leave gaping holes and just assume that people will find the information they need in the statute.
I hear that. Yeah, if you're going to make some clarification, it's hard to not restate the things that are clear in the statute in that context. So yeah, I hear that. I guess that's just a philosophical thing in general. Like, I would urge the commission to not adopt rules that are merely restatements of the statute itself. And especially the part that really got to me was where we actually just quote the statute in the rule in subsection 2, where it got me looking at the actual statute and realizing that they're almost identical. So my other comment on this section is subsection 3. I think the very last clause there could at least be implied to put a duty on public bodies that's not in the statute that I can find, which is that it says, in accordance with the requirements of the public records law and the policies or procedures adopted by the public body. I don't think our intention is that to require the public body to adopt policies and procedures to deal with it. So maybe we could say, and any policies or procedures adopted by the public body. For instance, the public body that I serve on doesn't have any policies or procedures that relate to this, and I wouldn't want it to imply that we have to create those.
Yeah, good point.
Thank you.
Okay, for once, a rule that doesn't affect Scott's clients. Okay, we'll move on to 199-050-0065. State Board or Commission meetings held through telephone or electronic means, video and audio recordings. And again, keeping in mind Adam and Rob's prior comments about putting the law into the rule. Subsection 1, a state board or commission that meets through telephone or electronic means must record and promptly publish the meeting on a publicly accessible website or hosting service so that members of the public may, without charge, A, observe a recording of the meeting if it was conducted through video conference technology, or B, listen to a recording of the meeting if it was conducted through teleconference technology that did not include video capabilities. 2, the requirements of subsection 1 do not apply to any portion of a meeting that was lawfully held in executive session. 3, the requirements of subsection 1 apply to any state board or commission within the executive department and whose members are subject to Senate confirmation. Joe.
I just have a flow issue, that's all. I would like to see point 2 and point 3 switched. Where point 3, you're talking about the requirement of the state board and commission within the executive department. And then point 2, you're talking about subpart 1 doesn't apply to executive session. I would just like to see 2 and 3 switched for better flow structurally in my mind. I don't know if that works for anybody else, but does that make sense?
Yes. Any other comments or suggestions? Okay. So we're supposed to take another break, but it's up to you. I can simply continue. We have one section left, and then we could perhaps get out early. Is that okay with the rest of you?
One thumbs up.
Right. Well, one thumb is better than none.
We got 2 more, 3 more.
All right, good. So we will move on to the grievance process.
Works for me.
199-050-0070 grievance process. Sub 1. The purpose of this rule is to clarify procedures regarding the requirements in ORS 192.705 for filing a written grievance with a public body alleging a violation by members of a governing body of provisions in public meetings law. ORS 192.610 to 192.705. 2, the written grievance must be submitted to the public body within 30 calendar days from the date of the meeting where the alleged violation occurred. The written grievance must identify A, the governing body that allegedly violated the public meetings law, ORS 192.610 to 192.705. B, the date of the meeting where the alleged violation occurred. C, the specific facts and circumstances that the person asserts amount to a violation of the public meetings law, or S 192. Yes, my counsel put on all these numbers. ORS 192.610 to 192.705. D, the date of the grievance. And E, the name and contact information of the person submitting the grievance. 3, a public body must conspicuously post on its website the person and contact information to whom a grievance may be submitted. The public body must accept grievances by email or other electronic submissions. In the absence of a designated person, a grievance may be submitted to a public body's chief administrator or to the chair of the governing body. Okay, I'll pause there. Let's talk about those first couple ones. Okay.
And Matthew has his hand up.
Yep, Matthew.
Yeah, so on 3, it's a public body must post on its website. And there were comments earlier about districts, small districts that don't have access, that don't have websites.
I'm gonna change that.
Chris O'Grady is next.
Okay, Chris O'Grady.
I think my other question on number 3 is, so is this rule, as I read it now, that a grievance has to be submitted by email or electronic submission? It can't be done verbally. It needs to be written.
It must be written. That is a requirement.
Okay.
It
Just
cannot be
wanted-
verbal.
Yep, just wanted to.
But I may need to change that sentence to clarify, they could mail it. It's just, you can't prevent someone if you have an email system and recognizing, Hasina, that there are districts that may not, and I'll work that in. That you, so that they can accept a written grievance by someone dropping it off, mailing it, emailing it, etc.
Nancy is.
Nancy?
Just grammatically, on its website should be at the end of the sentence. A public body must conspicuously post the person and contact information to whom a grievance may be submitted on its website. Flows a lot better than on its website, the person and contact information must be submitted.
Yeah. Liz?
And then maybe the question about the smaller districts that may not have websites recorded and stored somewhere, or does that need to be mentioned in would that cover those groups that don't have websites?
Yeah, I'm gonna find some way to work something in that would cover them. Okay, Joe?
There was a similar discussion regarding this in the Public Advisory Committee meetings. And the general consensus was that it was posted on a bulletin board if there isn't adequate website ability. The other concept was putting it in a local paper, but that gets kind of weird. The only comment that I have on point 3 is the word chair of the governing body. That just seems sort of off to me when it's the mayor or
Okay, I'll maybe rephrase that to presiding officer of the governing body.
Yeah, thank you. That would be great.
Nancy?
Just had a clarifying question because this is new to us city recorders. Will this be addressed in record retention as well? Currently, I think for cities, any requests and complaints have a minimum retention of 2 years after last action. Would these new rules or these new laws have the same record retention?
An interesting question. I mean, I would presume if your public body's record retention schedule or ordinances have 4 complaints, I think it would. I mean, you probably need to run that by your agency's council, but I would think so.
Well, most of us follow the state retention record.
Yeah.
Okay, thank you.
Therese?
Yeah, this is a little bit, this might be nitpicky, but in section 2D, it says the date of the grievance, which is separate and distinct from the date the meeting where the alleged violation occurred. I mean, I guess that means that a requirement of the rule is that the person making the grievance has to, put the date that they delivered it. I just wonder if that if it makes sense to require that, since to me, I think the date of the grievance would be the date that the public body receives it.
Look at the statute for a second. I put that in there because we have, of course, that provision that says if you haven't met the prerequisites, the commission must dismiss, and the prerequisite being 30 days. So the 30 days is they have 30 days to file a written grievance. So does that mean to put it in the mail? Does that mean I need to have some way of figuring out if they're meeting the 30-day requirement? Which is why I need to know the date of the meeting and the date of when you filed the written grievance.
Well, yeah, that kind of makes sense. I just wonder.
Maybe I need to rephrase that.
Yeah, because I just wonder, I mean, you could put, you could date it June 10th and then put it in the mail June 17th, right?
Yeah.
So it'd be like a timestamp or a postmark.
Well, and it also.
Should it read the grievance must be received by the public body within 30 calendar days?
What the statute says is filed.
Okay.
Chris O'Grady.
Yeah, I was just trying to think of a way to get around this if you wanted to put on the public body itself, if they, upon receipt of this grievance, needs to keep a record of when this grievance was received so that they can modify their own timeline. And then that goes to an issue that I'm seeing in number 4, and just staff that I work with that will be developing policies and procedures around this, is what does it mean to respond to a grievance and submit it to that person? Is it to send it to that person? I think there will be some confusion around the term submitted to a member of the public.
Quite possibly. The reason why putting it onto the public body as opposed to the person submitting the grievance doesn't completely work for me is, as you'll see in sub 6 and in the statute, the public body is supposed to send us a copy of any grievances they receive and their responses. And some are, albeit not all of them, but and that's fine. But the person alleging the violation, if they've done the grievance thing and they're submitting a complaint to us, they have to document that they have done all of those mandatory prerequisites when they file their complaint. So if they file a complaint and they don't attach a grievance and they don't tell me in their complaint and the grievance or show me that documentation I need to see that they met that prerequisite of the 30 days, I'm required to dismiss the complaint or put it on the agenda for dismissal. And so
I wasn't advocating for removal of this requirement, but if just knowing sometimes what happens in between different parties in matters of like this, there could be one date that this party says they sent a receipt, and there might be another date where they said they actually received it, and those don't line up. So it would be helpful in both instances to have it on with the person who filed and with the public body.
Yeah. Okay, we'll move on to. Did I already do 4 or did I stop at 3?
You stopped at 3.
Okay. Subsection 4. The public body's written response to the grievance must be submitted to the person who made the grievance within 21 calendar days from the date the grievance was received, and must satisfy the other requirements set forth in ORS 192.705 subsection 2. So before I move on to curing a grievance, any questions? I mean, I see your point earlier Therese, I think it was Therese or Chris, about submitted.
Yeah, it would just be helpful if it was clarified as sent or.
Okay. Joe.
In this particular instance, if you're submitting a complaint up by email, you have your email time, date, and stamp on it. I know that really doesn't address your problem, Chris, because of ambiguity in the date in which a letter was created versus when it actually went in the mail. I don't like shifting the burden onto the public, but maybe a receipt by certified mail would clarify and validate. Or in the alternative, at the same time that the grieving party submits it to the public body, they also send a copy or CC the Ethics Commission at the same time. Then there can't be no ambiguity as to when it was received or mailed or whatever. There's a lot of ways of proving validation of service, but it's the receipt issue that creates the problem.
Right, I would hesitate to put any sort of requirement that they send things by certified mail. I don't think we want to cost people that kind of expense. The other thing is the legislature chose to put in the requirement of the public body to notify us. They didn't put that requirement on the person submitting the grievance. Because there may be people who submit grievances that never end up filing complaints with us. They get a response and they're happy with the response. They shouldn't necessarily have to file a complaint. So, all right, Nancy.
Can we get rid of set forth and do like outlined or addressed? I think we're still using antiquated language and some of the things that we're trying to update. So it keeps setting us back instead of trying to progress us in the direction we're trying to go.
That's what happens when you get lawyers writing stuff. I don't disagree. All right, Jeb.
I'm wondering if this is just a question of, can somebody file a grievance about a violation of other parts of the public meetings law? And we get back talking about minutes and recordings. I mean, is failure to have recording or minutes for 2 years a violation of the public meetings law that is subject to this grievance process? Because it starts off saying we're grieving a violation by members of a governing body. And as was discussed before, some violations are by staff people outside the governing body itself. So that's my question about the extension of this grievance process.
So don't disagree about philosophically that. I think, as I think Scott and Rob and I have discussed, is that we may need a legislative fix for that. But right now, the grievance process applies to any violation of 192.610 to 705. And the only people who can be held responsible for a violation of those statutes are members of the governing body. In terms of your question, could we get a grievance or a OGEC complaint on a governing body's failure to maintain written minutes or recordings for 2 years? I mean, one, I think it would then be hard to meet the 30-day provision. And two, that one's touchy because it borders on public records law, which we do not enforce. So I don't have a good answer there. Deb.
So I mean, those requirements are within that body of law between 610 to 705.
Yeah.
So we haven't gotten into this. I guess you're saying that it may not be something that can be adjudicated or subject to grievance.
So if it's outside the 30 days, then it's not going to be adjudicated by ODEC. It would be dismissed because you have to have the complaint. You have to have the grievance in the 30 days. If it's, I mean, the only way you would have a situation like that falling within public meetings law is to say that it would violate that one sentence saying that you must make your recordings available to the public within a reasonable time. But that, I mean, I would argue that that does not mean must continually make them available for all time. That's obviously a record retention question. So
we have many public bodies with no minutes or recording for a year to 2 years. So it's just it seems like I don't know whether that's an area that the Ethics Commission will want to oversee and take grievances for. That was the question.
Tiffany has a question.
Tiffany. Oh, we can't hear you. Hold on.
Okay, how about now?
Okay.
No?
Yes, yes. Yes.
Oh, okay. Perfect. I wanted to make a comment about what should constitute the date of being filed. Let me lower my hand. I agree with what someone else said about not having certified mail. I think it adds an extra burden on the public, and it definitely adds an extra cost in just administrative process. So I don't think it's in favor of the public. So I wouldn't recommend having certified mail be required. Maybe you could have multiple options, as in the date filed is the date that it's postmarked or received by the body, because if they could maybe send it by email, if we're going to accept email service, postmarked, handed in person. So whatever date, or sorry, whatever happens first, because they might do a courtesy email and then also send it in the regular mail. That's just a suggestion.
Okay, good one. Okay, any other comments on subsections 1 through 4? Okay, cure provision, subsection 5. To cure a violation, the governing body must convene a meeting at which it presents the original decision, acknowledges that the original decision was made in violation of ORS 192.610 to 192.705, and votes to A, rescind the decision, or B, reaffirm the decision. If voting to reaffirm the decision, the governing body must identify the good cause that exists for the governing body to reaffirm rather than rescind the decision, and must hold the meeting within 45 days of the original decision. Chris.
Yeah, I think what's interesting to me here is this seems to only offer a cure of a violation in which a public body or governing body held the meeting where a decision was made, because I think there are often sometimes meetings where something was discussed, but nothing was decided upon. And if the violation wasn't regarding an aspect of the meeting where a decision was made, how does that the governing body then cure that violation if it's not a reconsideration of a decision because no decision was made?
Yeah. My problem is statutory language. Because it's the statute that uses this phrase about decision. When the statute talks about, when the public body receives the grievance and prepares its response, it's supposed to identify, either deny the facts or admit the facts, deny a violation, or, and the statute specifically lays out, if you admit a violation, in your response, identify the steps you will take to cure the violation, and then talks about, these things, rescind the decision, etc. Arguably, I would say that any violation of the public meetings law would require a public meeting I'll give you an example. This happened in the context of an executive session violation, but where a governing body was meeting in executive session and was discussing salary and benefits. You're not allowed to discuss compensation in an executive session. So after the executive session, after the meeting was over, someone brought that to their attention, but someone also filed a complaint. But before they filed the complaint, the governing body, at least in a common sense way, cured the violation. How? They held a public meeting where they repeated everything that they said in that executive session in a public session because they weren't allowed to hold it in exec. And I mean, the whole point of having another meeting where you present it. So if your violation was you failed to provide notice within the time frame, notice a new meeting and fix it. If your violation is, you failed to provide an accessible place for the public to view a meeting, renotice the meeting and do it over.
Yeah, I just don't know if this language gets to those instances, or like, for example, as a state agency, if we received information or a grievance saying that we didn't notice a meeting of our governing body appropriately, we would respond and say we would admit or deny, and then say for all future meetings, this is how notice will be conducted, and this will be and ensure how we're meeting all of the notice requirements. But let's just say that in that governing body meeting, we only talked about systemic issues that my agency talks about, early learning and care. So we were only talking about those things, but there were no rulemaking actions. There were no other actions that our governing body voted on. It was purely just discussion. And so the cure is more focused on procedure of meeting notice requirements moving forward, rather than this cure of violation in section 5 seems to just be very narrow on my read, but maybe it isn't for other folks. And
No, I think it is narrow, partly because of that word decision that's in the statute, but I think part of it is, even in that situation where no decision is being made, if the meeting was not properly noticed, is it a cure to say, okay, in the future, we're going to do things right? Should you adopt that as a policy? We're going to try to do things better next time. Absolutely. But if the question is, are you curing the public meeting? If the whole point of the notice and everything else is to provide transparency to the public, have you cured the violation by saying you're going to do it better next time? Or do you cure the violation by reholding the meeting, giving the public notice, making it accessible, whatever it is?
well, the clause says if the decision wasn't made and there was, and the agency admits a violation or says that there was a violation, what's the other method of curing violations of those matters when there was a a meeting where a decision wasn't held. And I see other people have their hands up, so I'm sorry for going on this back and forth.
Okay. No, I mean, this is an interesting topic for me. So that's okay. Sarah.
I just think that this is the classic case where the statute is being restated here, but a little bit differently. And in this case, I think I agree with Chris that this seems really limiting. And the statute actually says, it lists out those responses, but says including but not limited to, and then it gives some examples. So I think the statute is more broad than what the rules are written here. And that's kind of that conflict that I think others have mentioned a couple of times.
So if this were broader, and I accept that if this were broader, say you have that meeting, Chris, where a discussion, state agency, we had a committee, they had a discussion, the meeting wasn't noticed. What would be the cure for that?
Well, I think that's us as an agency asking what we would need to do in order to cure that. Would we then fix the notice and point people to minutes that we had of that recording, and then say in future meetings we will fix our notices? Some of these our meetings are 4 to 6 hours long, where they're just talking about infrastructure ideas. Like, would we have to rehold the 4 to 6 hour meeting in order to cure that violation and have the same topics and the same presenters come? That's what I'm trying to ask. Is I think we're looking for guidance on how this would be interpreted, and then who would be responsible if that isn't a cure, or if we're not able to do that given the resources. Would it be the members of our governing body or the staff of the public agency?
I mean, this is the one under the public meetings law. It's the members of the governing body. So this is the one area where, keeping in mind, I understand Jeb's concerns about audio recordings versus minutes or something, but where having that audio or video recording may be the cure. Because while ordinarily I would say you're going to cure it by renoticing and reholding that meeting, making it available for the public. But if it's recorded, couldn't the cure simply be by renoticing the meeting as being accessible on this recording and making the recording available such that the public could observe the meeting and the discussion in that manner?
Yeah, I'm not saying that would be ideal in that situation at all. I'm not saying that's the gold standard that we would need to hold ourselves in, but I think what is making at least folks in my agency nervous about what this is I think the difference for curing a violation and the different types of violations that could happen, they'll have really different implications for what an agency does to move forward or what a public body does to move forward to address if there is a grievance process and how to actually cure it. And then if that process is laid out, that we would have to rehold the entire meeting if we couldn't get the same presenters or the same content of the meeting again. What would be the penalty assessed for liability to our governing body members, and which governing body member would that be?
Yeah, just taking some notes here. Therese.
Yeah, I think part of the confusion here is that 192.705 that describes the written grievance, process and required response. It doesn't require curing the violation. Like that is a piece if there's a decision, and we've been discussing that, but you know, and it also there, let's see, 190, so in 705, 2C23, very deep buried in that part of the statute, you know, one potential cure is modifying practices to ensure future violations do not occur. I don't see that in the rule here, which I agree with others who've said that the rule shouldn't just, you know, regurgitate the statutory language. But, you know, to go to Chris's concern, I mean, if the violation did not involve a decision, which could then be, you know, redone, then, you know, a potential cure of the violation might just be a discussion that's held within 45 days about, you know, how to modify practices to make sure that doesn't happen again. And that seems perfectly within what's required by the statute, but this rule sort of suggests that the statute requires a cure that related to a decision. And I think that that's, to me, that's confusing. And that might be part of I could be wrong, but I think that might be part of the confusion Chris was talking about.
Okay, valid point. Joe?
Oh, is that me? Oh, okay. Yeah, I can see where this is a difficult area. That the fact there could be an administrative violation is different from a notice and an activity and a decision-making process, and they would have to be separated somehow, because it, you know, failing to post minutes would not mean that you have to go back and rehold meetings. But it also may be true that since that none of it applies to minutes and that kind of administrative process, because it's not a violation of the governing body, it would be a violation of the administration. You know, so that would get confusing. But certainly, I wouldn't be advocating having people to have to go back and rehold meetings because of some subsequent administrative failure to follow part of this ORS.
Yeah, I mean, valid point, that if it were something like failing to make the minutes available within a reasonable time period, reholding the meeting doesn't change that. So I will take another look at this.
Yeah.
No.
My comment is sort of like convoluted between Scott's knowing and intentionally and Chris's issue of how do we correct it. My issue is, what if the governing body holds the discussion, gives a theoretical cure of, okay, we had the discussion, this is our cure, but they keep repeating that same thing without any corrective action, except for saving face and acting like they're doing it. You know, oh yeah, we had a subsequent meeting to correct the previous failure of our other meeting, but yet a couple of meetings later, they do the same thing again, and this is a repeated pattern. How do you stop a repeated pattern? To me, that would seem to fall on the Ethics Commission for the complaint itself being a continuous and repeated pattern. But I don't know. I'm totally all over the field here.
There will be governing bodies that repeat the same thing. They, whether intentionally or unintentionally, that will happen. That would be addressed through the actual complaint and preliminary review and investigation process, and will be addressed in the penalty matrix as well. So, you know, even if a governing body takes a step to cure its violation, that doesn't mean someone can't still file the complaint with OGA. They can. So if they say they're going to cure and they don't cure and they do it again, the person certainly has every right to file a complaint. Deb, did you have another comment? And then we'll move on to Matthew. Okay. Backwards, yeah, Matthew, sorry.
Oh, thank you. So one comment, and it's probably not under the purview of this committee here, but I found it interesting that under 2C1, it allows the governing body to just simply rescind the decision. And then, but under 2(3), it adds the extra requirement to modify your practices to ensure future violations don't occur. But that's not that provision's also not under the situation where you're rescinding the decision because you're admitting the violation. So
yeah,
I don't know if that made sense, but that seems to be more of a legislative, maybe a fix that part shouldn't fall under one of those options. It should be a separate requirement for the response, I guess. But the other part was just, I guess, practically speaking here, when you've got the complaint, the grievance about the public body, and then you're asking for a response in which they're admitting or denying something, you're going to need to have a meeting in order to discuss that.
Yep.
Right? So you're going through all these facts that it looks to me, it seems like it has to be laid out. And you got to do that in the public meeting to then put it all back into a letter and say what you're going to do in the future, which you may have already cured the violation, addressed already by having the meeting again. It just seemed, I was trying to work through this before with a client, and it was so convoluted in the steps you need to take to address it, that I think my brain's just fried up with it. But
your thing having this 45-day, you can, hold a meeting to cure it within 45 days, but you have to do your response in 21 days.
Right. But even to get to that response, you need to have the meeting with it.
I think that's more of a legislative fix certainly to the grievance timeline. Yeah. Adam.
Hi, my comment was on subsection 3. The public body must conspicuously post on its website, but then it goes into saying in the absence of a designated person who this grievance should be submitted to. I think we should consider whether that's really a requirement that you must post it, for the same reason a number of people have mentioned some bodies may not have a website. It feels like an extra requirement that's not necessary, especially with a lot of public bodies. It's going to be very clear how to contact them, how to submit, documents to them. So I don't think it's necessary that everyone does it. I think maybe that would be a great thing, like may post it on its website, but otherwise the backup rule should kick in.
Okay. Okay, last section, and we will be done for today. So the last section, 6. As required by ORS 192.705 sub 3, the public body must submit a copy of the grievance and its response to the commission. The submission of the grievance and response to the commission can be made by mail or by email at the email address identified on the commission's website. And we have a separate email just for public meeting law grievances, but that's it. All right. Final comments from anyone? And Chris.
So my last question on that is for number 6 going to be a time bound?
There is not. Well, I mean, I would recommend, and I don't know if we want to put it into the rule, the statute doesn't put a time frame. If a public body, the whole point, at least in my mind, of having the public body submit their grievances is self-protection in a certain way, you know, so that if a complaint's received, I can, and they say, yeah, I filed a grievance and they never responded and 21 days passed. But I can then go look in this pile of grievances that I get from public bodies and say, they sent it to me and they sent me this response. So somebody's lying here and it's not the public body.
Yeah, I guess as a member of an agency, I think it would be helpful for our staff in developing a policy and procedure to have a time bound on when we submit the copy of the grievance and the response to the commission. And I think this aligns with the intent of the legislation if you really want to be able to track what a public body's response is to the public, but I'll let other folks go in.
The statute actually says at the time the public body responds to the person who filed the grievance, so it is time bound.
Okay, my staff corrected me. The statute does say at the time they respond. So I can make this clarified in the rules. Liz.
I guess I don't know if I got confused or not, and I may be confused, but you were saying something about there may need to be a legislative response or answer for the decision for the 5B section and that wording of decision. Would that have to be a legislative change?
No, I think what we were talking about, I will work on this rule. I mean, obviously my problem was that the phrasing of decision was in the statute, but let me look at this rule itself and see if I can fix or improve it. But I think what we were talking about being a legislative fix is potentially looking at, do the timelines actually work in practice where a public body has to give a response in 21 days,
right?
But then it has 45 days to hold a meeting at which they can cure the violation. And do they need to meet to give the response? Is that even always possible in a 21-day period?
And I was, can I add to that? Is it, or in looking at that, does it have to be, like I was listening to the young lady that was talking about 4 or 5 hour meetings, because some of us have those. Would it be the whole meeting that has to be repeated or just the section? Because I know they don't timestamp when they do, or some groups do not timestamp either. But if there was a way to timestamp where the grievance is and only hold that part of the meeting, I guess, that resolves, that seeks to resolve or give an answer to the grievance. That makes sense?
Yeah. And I mean, I like I said, I'm gonna revisit this. Yeah, go ahead, Adam.
So I guess, and tell me if this is the wrong time, I can come back later, maybe at the end of this meeting. But I missed the detailed discussion on the definitions rule. And Susan, given our discussion earlier this morning about the definition of judicial proceeding for public meetings law, is that something that the commission would like to consider adding a definition rule? That might be a clean way for the commission to weigh in on its belief in how to interpret judicial proceeding.
Okay, Scott.
Thank you. I guess if we're doing final comments, there's a theme or a thread in the rules today, and I think you could maybe in some of the previous meetings too, where it does seem to me that there's a strong potential that the OGEC could find itself substituting the judgment of the local government in some problematic ways. And so I'll draft written comments when I've formulated what I think the fix is, but there are some areas we've talked about today where, the OGEC could find itself determining whether or not it was an emergency meeting. And, emergencies are I mean, that's very subjective. And on the curing of the violation, you know, this is an area of law where our legal counsel for cities have a tremendous amount of experience. They deal with it daily. And it just strikes me that you could have a city council that has done everything to either cure a violation or made some other judgment that was well within their power to make, and find themselves on with a complaint. And that's very problematic to me. Some of this I think we're stuck with in the statute, but I do believe that there may be a way to mitigate some of that concern. And I will submit the appropriate written comments.
Yeah, I appreciate it. Okay, Joe.
I agree with Scott, but on a different side of the page, when you have long-term staff that are pros in their job and they know how to do it, and yet when you have young city council members, like earlier in the discussion, I think it was Lakeside or Lakeview, where they had 3 new council people and they were totally green as to the criteria. It's sort of, you know, there has to be a guiding light here of what is expected versus the mandatory. I mean, there's a difference between you will do this or we would like to see this done in this fashion sort of thing. I mean, I don't know if I'm making sense, but yeah.
Okay, long session. Actually, your comments today are helpful, and I will continue to work on these, and we'll send revised versions out once I have them. We still have a couple sections left, which are the sort of complaint process and then the training, rules around training. So I will get those to you as soon as I can, and please send your responses into the rulemaking email address. All right. Oh, wait, any other questions? All right. Sounds good. I'll let you all go.
Susan?
Oh, wait. Adam, you had your hand up. He's clapping. Oh, okay. Sorry. All right. Yeah, Joe, did you have a comment?
Yeah, I'm not being polemistic or argumentative or cantankerous or anything like that, but could somebody explain to me why Oregon does not allow public participation, that it's at the discretion? I mean, I'm trying to wrap my head around this to understand, given the whole concept of transparency here. And when you look at land use laws, the first rule, state rule number 1 goal is community involvement at inception.
Yeah. I mean,
So,
there are lots of laws.
I mean, isn't that what our local governing bodies do? They're governing a landmass and making decisions for their people, you know, and policies and practices. I just don't understand why the legislature doesn't want to mandate part of the APA Act. And
I would encourage you to contact your local legislators.
thank you, Susan.
All right, I'll let you all go. Send in your comments and suggestions if you have them, and we will be in touch with the next section or a rewrite of this section.
They'll also get the post survey.
And you'll get a survey.